We often get questions about protection orders, particularly in a domestic violence context. These questions include: how do I even get a protection order? Who can it protect? And how long can a protection order last? Today, we're going to answer some of these frequently asked questions about protection orders, starting with the what. What is a protection order? Well, as its name sort of indicates, it's an order that protects someone. They're also known as restraining orders. A protection order can prevent and order a person to not tamper with, harass, stalk, or come near someone's residence, someone's place of work, or even a family home. The first step, the first step to getting a protection order is to file a verified motion and complaint with the court. This document is where you can let the court know essentially your story, and you want to be as specific as you possibly can between details and dates and places. You are painting a picture for the court to understand why you're asking for this protection order. Why should the court grant this protection order? Now, this first phase, if the court grants and reads your complaint and finds that there are grounds to grant a protection order, that protection order is a temporary protection order. And you can get that protection order without the other party being present. In fact, some judges will issue them without you even appearing before the court if your complaint or motion is sufficient for the court to grant a temporary protection order. You do have to show that your life, your property, your health, your safety is in imminent danger from the person that you are trying to get an order against. We often get asked, can I include my dog or my cat in my complaint? The person threatened to hurt my animal. Yes, you can. You can include your pet, and you can also include children, minor children under the age of 18, if you believe that their life, their safety, or their health is also in imminent danger. After the temporary protection order is issued, you do have to serve the other person. And usually this can be done through the sheriff's office. If you know where the other person is located, the sheriff can go and serve them with a copy of the order as well as information about the next court date. Now, on the next court date, and we personally try to prepare our clients and make sure that they do know that while at the temporary protection order stage, you did not have to see the other party. At the permanent protection order stage, the other party does have the ability and the right to participate in those proceedings. So they have the right to present evidence just as you do. They have the right to present testimony and any witnesses to show the court why this protection order should not be granted, whether it's disproving your allegations or showing that the harm is not continuing. You have the same right. You have the right to have a lawyer present. You have the right to submit testimony, evidence, and have your own witnesses come. Now, at the permanent protection order stage, we frequently get clients who say, I didn't prevail. I don't understand. They've usually done the hearing and then seek a consultation or retain us. And usually it's because they haven't met that burden of imminent harm, continuing. So you have to show the court, why should the court grant this protection order? What is it? If the court did not grant this protection order, what would happen to you? How would you be in danger? How would your pet be in danger? How would your children be in danger? So always remember that when you're putting together your testimony and evidence, and even if you don't retain an attorney, it may sometimes be helpful just to do a consultation with an attorney and get some help sort of looking at your evidence and seeing what you might need to prove or what's missing or what might be helpful to know. Once you get your protection order, hopefully you are successful in doing so. Once you get your permanent protection order, it is just that. It is permanent. Unless there's some exception or there's a date listed on the bottom of it by the judge for some reason for when it will expire, it is a permanent protection order. We recommend and we always advise our clients, please make sure that you carry a copy of that protection order with you. If the person who it is against violates it in any way, you can call the police. In Colorado, it is a crime to violate the protection order, even if it is a civil one and not a criminal one. It is still a crime to violate that protection order. I hope this video was helpful, and we'll see you on our next frequently asked questions.